Okay, I can't believe we're already in chapter 3. This is an 8-week course, so it is fast moving. Don't forget to turn things in on time. No late assignments just because it's so fast and I got to get things graded and back to you. Alright, so chapter 3. We're talking about documents that are common to almost any type of business entity. And you should really, as a paralegal in business law, have these memorized and just be able to rattle them off the tip of your tongue. Again, chapter objectives you can read on your own. Okay, so here's a list of all of them, and we'll discuss what they mean, but you need to memorize them. So we've got professional license, registration of intellectual property, fictitious business name statement, sales tax, business license, workers' compensation insurance, unemployment insurance, Social Security, and a federal employer identification number. Okay, so professional licensing, I've given you an example of, it's a bar card, which they no longer give to attorneys. You have to specifically pay extra for it now. But basically it's a professional license, but I don't mean just like doctors, lawyers, accountants. Cosmetologists have to be licensed. Plumbers have to be licensed. Electricians have to be licensed. So any sort of professional job, almost any job at all has to have a license for the people to do it. And so you have to make sure that the client has that license to do their job. Otherwise, they're probably in violation of the law, and we are not allowed to help anyone break the law. Big exceptions to this rule are a lot of computer professionals don't have to be licensed. But whenever somebody comes to us and we're not sure, we need to check and see if they need to have a license to do their job. And then we need to actually see their license, and it must be current. All right, registration of intellectual property. So this is the stuff that's kind of intangible, hard to see, but can be the huge value of a business, like the secret sauce. So we have to think about these things and see if the company has any of them and protect them. All right, so patent is typically for something that's useful, like a door lock. And so that would get a certain type of protection of anywhere from 14 to 20 years, depending on the type of patent. And there are 3 main types of patents. The last one, the utility patents, is actually the most common. It's something that's useful, that's non-obvious, that hasn't been thought of before. So a door lock, sometimes even like a drawer pull could be a patented item. Curtain rods, more utilitarian things. The next most common is a plant patent, and the example I like to use is halos or cuties. Those were not naturally occurring. They were reproduced and altered so that it would be easier to peel for little kids and adults alike. And then the last one is a design patent, and Lady Gaga has great design patents. She'll do things like make a piano in the shape of a shoe, and that is a design patent. So utility typically gets 20 years, plant 20 as well, and design only gets 14 years protection. So what is excluded from patent law? A naturally occurring product of nature, so just a regular tangerine wouldn't be patentable. Books typically aren't patentable. Atomic weapons, thank goodness for not. And we won't go into the business methods. Okay, so we used to believe that whoever came up with the idea first should be able to get a patent, but now, since that was so hard to prove, we believe in whoever's first to file with the U.S. Patent and Trademark Office. And that leads us to trademarks. So a company's image, if you will, is often some of its most expensive items. Like Coca-Cola is considered billions of dollars because of things like the traditional Coke bottle logo, and the red and white is very known all throughout the world. So things like I'm loving it for McDonald's, a phrase, a word, a logo, all this stuff called trade dress that makes us think of a product can be trademarked. There's 4 major types of trademarks. There's trademarks, service marks, collective marks, and certification marks. And a trademark is for good, a service mark is for a service. So like H&R Block is a tax service, so that would be a service mark. A collective mark is like a whole house full of goods, like General Mills has tons of products underneath it, so that would be a collective mark. And there's also certification marks, like the Good Housekeeping Seal of Approval, for instance. Okay, we'll skip this one on the trademarks. Alright, and then there's 5 major subcategories of marks. There's generic, descriptive, suggestive, arbitrary, and fanciful. And generic is, you can't trademark it. It's like you just said, oh, this pen is the best pen ever, so I want to call it best pen. Well, you can't trademark that. Let's say you're a little bit more descriptive, like Mr. Clean. Well, that's not very special, but if you put a bald-headed man with lots of muscles and a white shirt and pants on, you can get eventual trademark protection. Suggestive is a name that's suggestive about something about the product, so like legs, L''EGGS. Pantyhose used to be in an egg, and it's called legs, and it's for ladies' legs, so that's suggestive. It can definitely be trademarked. Arbitrary can be trademarked as well. Something like calling a cell phone an Apple cell phone is arbitrary and can be trademarked. And then sometimes we have fanciful names for things like Kodak is fanciful for cameras, and that can be trademarked as well. It's not just words, though. We're talking about all the things it can be. It can be letters like ABC, CBS, car symbols for the different cars, such as Lexus. And every 5 years, you must say that you're still using those trademarks. Then one of the famous cases was Menashe versus Victoria's Secret catalog. And the plaintiff, Menashe, she wanted to have sexy little things as her lingerie. Well, she couldn't do it because Victoria's Secret had used the term sexy little things first. So Victoria's Secret got to keep it because it was basically part of their trademark. Alright, copyrights are more for those written things like books, movies, photographs, artwork, music, some architecture, and it has to be fixed and tangible in some way. It has to be an original idea. So, for example, my book on business law is not the first time business law has ever been thought of, discovered, but it's my interpretation, it's my original thought on business law, so that is copyrightable. Copyrights are a lot cheaper than patents, and there's a lot of overlap, so with clients I tell them to file a copyright oftentimes because it can be cheaper and faster. It also typically lasts longer for up to 70 years after the death of the last author, so if I had a co-author in my book, whichever one of us died last, plus 70 years, that's how long the copyright will last. If the work is by like Disney, for example, then it's 95 years for publication, 120 years from creation of the idea. So Disney has a lot of stuff left in their vault. They're just sitting on it, waiting to release it. They get 120 years from the time that Walt Disney basically created it, or whoever at Disney created it. So what rights do you get if you copyright something? Well, you get to reproduce that thing. So if you have an Ansel Adams black and white photograph, you can put it on t-shirts and mugs and sell it. You can adapt it. So if you're like J.K. Rowling and you have the Harry Potter books, you can make them into movies. You can distribute your work, sell it. You can perform it like in a play. You can show it off at a public library, museum, etc. Okay, so the first sale doctrine is something that's very important for students. It basically says that you're allowed to buy a used textbook. That is allowed. You are not, however, allowed to Xerox that textbook and then sell it. That's not allowed. So if you buy a book, new or used, you have the right to resell it, but you don't have the right to copy it and then make money off of those copies. Is basically what the first sale doctrine says. So copyright, I get some very limited exceptions. Like if I hear a great news article at the last second and I want to tell you guys about it, I have a limited exception that says I'm not violating copyright to provide that to you. That's a very limited exception though. Some charities can use things like Andrew Lloyd Webber's Joseph the multicolored coat for fundraising without having to pay. And some charities can get out of being in trouble for copyright violations as well, but there's limited exceptions to copyright violations. So if the work is for hire, then the person that owns the copyright is the employer or the person who paid for that. So, for example, I've written 2 books. The first book I did for hire, okay, so that company owns the copyright. The second book I wrote, I did it for myself, and I own the copyright. And that's part of the reason why I can charge $45 versus $200 for the book. Alright, trade secrets. This is the secret sauce we were referring to earlier. You really just have to keep it a secret. There's no way to really protect it other than asking the court to tell people not to use the secret sauce, but you need to try to be protecting that secret sauce. Alright, skip that one. Going on to fictitious business name statements. So, my other business is the law offices of Emily Lynch Morissette. So because I have my full legal name in that, I don't have to file a fictitious business name statement. But if I wanted to be the law office of Emily Morissette, that's not my full legal name, I'd have to file a fictitious business name statement. If I wanted to be the law office of Morissette, it's not my full name, so I'd probably have to file a fictitious business name statement. If I wanted to be the law offices of Emily Morissette and children, because even though those children might have my same name, they might not, so I'd probably have to file a fictitious business name statement. Alright, sales tax is imposed upon goods. Goods are typically anything that can be moved, and luckily for me, services are typically still not taxed, because if somebody had to pay taxes on coming to see me, they'd probably be less likely to come see me. Or if somebody had to pay taxes on veterinary services or medical care, they probably wouldn't get that medical care. A business license is imposed by the local entity, typically a city, and they're just trying to regulate businesses within their borders and making sure that they're not just being illegal like prostitution. And typically it's not so expensive. It's usually under $100 and about a page or 2 to fill out. Workers' comp insurance. If a business has employees, they typically have to have workers' compensation insurance. And if they can't get it on the private market, they can get it through the state. It's known as the State Workers' Compensation Insurance Fund. and they can get cheaper insurance that way. Unemployment insurance, the employers pay into and employees typically do not. And the employee may not get it if they've been fired or if they quit. Social Security, typically the employer has to pay into Social Security for the employee. And finally, the employer, if they have employees, they have to do a federal employer tax identification number with the IRS. And it's like a Social Security number for the business. And it just helps the IRS keep track of taxes.